they're looking at a single projectile. Those are the words that they're really focusing on. And with these firearms that are capable of potentially hosting multiple calibers, well, that's not a single projectile. We are the Armed Attorneys. Today we're talking about a pretty wild update when it comes to maybe some firearms that skirt the NFA that seem very similar, but are not subject to regulations such that you would need to register them, pay a tax stamp, jump through all those legal hoops, but get to enjoy kind of the same benefits. But before we begin, show your support for the Second Amendment by hitting that like button. All right, Stealth Edit. We produced this video, and then we got a new letter from the ATF. We're going to be discussing that at the end, but the rest of the discussion is still good, so we're going to roll with it, and then we'll pick back up. And I got one, I'll save this for the end, but I got an idea, and whoever can make this happen is going to be a gazillionaire.
Yep, I agree.
I don't have the technical capabilities to do this, but we'll talk about it. Leslie Cross, good to see you.
Yeah, you too.
So what we're talking about is, and this comes out of Franklin Armory and a line of firearms that they have. They've been in some kind of protracted litigation. Recent settlement. We got a statement from the ATF. Going to be going through that. Some additional clarification from Franklin Armory, and there's a lot of interesting things here.
Yeah, no, I agree with you.
So I think before we kind of dive too much into this so that folks can really understand what's going on, because we've got a lot of people asking us questions about this, and I think there's a kind of baseline knowledge you got to know.
Yeah, no, I agree, and it's kind of gone back and forth, which is interesting.
Yeah, so we're going to start here because before we dive into the firearms themselves, we got to understand what we're fighting about. We're fighting about the definition of a rifle for purposes of, hey, are these things regulated under the National Firearms Act? And I'll just go through that very quickly. This is an 18 U.S.C. 921A7. The term rifle means a weapon designed or redesigned, made or remade, and intended to be fired from the shoulder, and designed or redesigned and made or remade to use the energy of an explosive to fire only a single projectile through a rifled bore for each single pull of the trigger. All right, got our baseline here. Now, have this case. This happened back in February. We got some interesting kind of conclusions out of the analysis of the firearms from Franklin Armory. Ultimately led to settlement, and then we got this statement from the ATF.
Yeah. So the original case was FRAC v. Bondi, and they kind of were fighting back and forth. They came to a settlement agreement, and then out of that agreement came this letter from the ATF. So I'm just going to go ahead and kind of read this letter so we can see exactly what the ATF is saying, and then go from there. This is the open letter to all federal firearms licensees regarding the Franklin Armory Reformation and Antithesis firearms. The purpose of this open letter is to advise all federal firearms licensees, or FFLs, that the Bureau of Alcohol, Tobacco, Firearms, and Explosive, ATF, is rescinding a prior open letter dated December 19th, 2019, regarding the Franklin Armory Reformation firearm. This open letter also advises FFLs on the classification of the Franklin Armory Reformation and Antithesis firearms under federal law. And this letter that I'm reading right now is dated August 29th of 2025. Background. Pursuant to the settlement agreement between the United States of America and the Firearms Regulatory Accountability Coalition and Franklin Armory, ATF is rescinding the 2019 open letter regarding the Franklin Armory Reformation firearm. The 2019 open letter advised that the ATF Firearms and Ammunition Technology Division, FATD, examined the Reformation for purposes of classification under the Gun Control Act, GCA, and the National Firearms Act, NFA. FATD opined that the Reformation firearm was a shotgun subject only to the provisions of the GCA. However, if the Reformation was equipped with a barrel less than 18 inches in overall length, that firearm would then be classified as a short-barreled shotgun, SBS. Separately, FATD examined the Antithesis firearm for classification under the GCA and the NFA. The Antithesis is a type of firearm that utilizes a 14.5-inch rifled barrel to fire 410 bore shot shells and slugs, in addition to 45 Colt cartridges. As such, FATD classified the Antithesis as a short-barreled rifle under both the GCA and the NFA. This classification was vacated. Current status on the Reformation. Pursuant to this agreement, the Reformation is not a short-barreled shotgun under 18 U.S.C. 921A6, short-barreled rifle under 18 U.S.C. 921A8, or a firearm under 26 USC 5845A, and is not subject to the requirements of 18 USC 922A4 and 18 USC 922B4. Furthermore, pursuant to the terms of this agreement, the Reformation is compliant with all applicable registration, taxation, or other requirements under the GCA and the NFA, and any such law incorporating by reference any such requirements. In other words, as a result of the agreement, the Reformation is not a short-barreled shotgun, short-barreled rifle, nor is it an NFA item. Therefore, 1. No NFA forms are necessary to sell, transfer, transport, deliver, or otherwise deal in or possess the Reformation, and 2. No ATF Form 5320.20 application to transport interstate or to temporarily export certain national NFA firearms is necessary to transport the Reformation across state lines because the firearm is not subject to 18 USC 922A4 or B4.
I'll read the last part. So,
Okay.
current status of Antithesis. As a result of the agreement, the Antithesis is not a rifle, short-barreled rifle, nor is it an NFA firearm. Therefore, no NFA forms are necessary to sell, transfer, transport, deliver, or otherwise deal in the possession of the Antithesis. And 2. No ATF Form 5320.20 application to transport interstate or temporarily export certain national NFA firearms is necessary to transport the Antithesis across state lines because the firearm is not subject to 18 U.S.C. 922A4 or B4. So sales and transfers of the Reformation and Antithesis firearms. The Reformation and Antithesis are firearms under Section 921A3 of the Gun Control Act, but are not rifles or shotguns pursuant to the agreement. When transferring these items, FFL should utilize the other firearms box in Block 24 on the ATF Form 4473. Should you have any questions, call the ATF. So, all right, let's put that in plain English. We wanted to read the whole thing because, we're going to give it to you straight from the horse's mouth. Now, what are they saying here? And why did we give you that definition of rifle? Well, this all hinges on, and I'll give you the case number. It's in a footnote in this letter. This is in a motion for summary judgment, the Firearms Regulatory Accountability Coalition and Franklin Armories v. Pamela Bondi. This is case number 123CV0003, and this is the Northern District in North Dakota. So, what are they saying here? Well, all right, if we go back to that definition of rifle, what are we focusing on for purposes of this kind of lawsuit where this motion for summary judgment vacated for the settlement agreement? They're looking at a single projectile. Those are the words that they're really focusing on. And with these firearms that are capable of potentially hosting multiple calibers, well, that's not a single projectile. We have 45 Colt, 410 shotgun. Guess what? We got 2 different projectiles here that this firearm is capable of discharging, and therefore we step out of the definition of rifle for all of our discussions here, and now we're just landing in the firearm category. So that's quite the interesting thing.
Yeah, no, very interesting. That's a very good outcome.
Now, Franklin, we got this letter from the ATF a few days ago. Franklin Armory followed up with some clarification just a couple of days ago. I think we should just go through that very quickly. And this is dated September the 19th, 2025, and they were talking about their Antithesis line of short-barreled firearms. So what they're saying is, last night the Bureau of Alcohol, Tobacco, Firearms, and Explosives requested that we voluntarily bring back all 5.56 caliber Antithesis firearms in advance of the agency issuing a new classification. We were surprised in light of the U.S. District Court's ruling in FRAC v. Bondi, out of an abundance of caution for the well-being of consumers, dealers, and distributors, we are voluntarily requesting all of our customers return their 5.56 caliber Antithesis firearms for a full refund. So that's where the hiccup is.
Yeah. So interesting. So August 29th, we get a letter saying all good to go. And then September 19th, we get an update that says, well, maybe not all good to go as far as the 5.56 is concerned. And just to be clear, there was no change in the Reformation line of firearms. That line of firearms is still same.
Yeah, good to go into the settlement as far as we know. Yeah.
Right. So it's just the Antithesis and it's just the 5.56. So why do you think that is?
Well, probably because we don't have again, we're focusing on this single projectile issue. I'm not aware of another cartridge that's compatible with 5.56, and I think that's where the ATF is trying to hang its hat.
Yes, no, I agree with you. I think that's it. So, I mean, the question is, does this mean that the ATF is going to come out with a new ruling as far as a new classification of firearm? That's kind of what it sounds like the writing on the wall is. And if so, what is that? Is the ATF now going to require, a tax stamp for the 556 version of the Antithesis? And then, great question, what does it mean for everyone who, bought this firearm in between the time that it became legal and now this time?
Yeah, well, it sounds like Franklin Armory is doing a fantastic job offering refunds to all their customers. I mean, these guys, they don't want people to get in trouble. I can't tell you how many, and I talk to gun stores all the time. I mean, they really, really go out of their way, maybe even above and beyond what they need to do to try to keep everybody on the right side of the law. I mean, and this is why I hate folks, this fiat stuff, when we don't pass a law, when we're just passing opinion letters and settlements and all these other things. This could all be wiped away with another administration. So that kind of drives me nuts on this end. But I do have an idea for an enterprising person who wants to become a gazillionaire. I don't have the technical knowledge for it. And it's that we need to come up with a platform that's capable of accepting 556 and a brand new shotgun caliber that doesn't exist yet.
Yeah, that'd be great. That'd be great if someone came up
Once
with that.
I mean, because if we're going to follow this logic, this single projectile issue, well, I think we've found a hole in the NFA. And Congress meant what it said when it wrote down the laws. And if they wanted it to mean something else, they would write it that way. But they said that for a specific reason.
No, I agree. So what do y'all think? What do you think should be the outcome of this? Do you have any other ideas, anything that could help solve this problem? And what do you think is going to be the ATF's next move?
All right, back to kind of stealth edit. Leslie, you changed clothes.
I know, look at that.
So we got a letter from the ATF. This came out on September the 25th. And I think this had some clarification in what we just talked about.
Yeah, a lot of clarification.
We kind of got some, I had that brilliant idea. Well, it seems like Franklin Armory had the same idea, and the ATF does not like that.
They did not like that idea. Yeah, basically what they said was that Franklin Armory, the 556, what they did was they came up with a special cartridge that was going to shoot more than one shot. And they called it, I think it was an exotic ammo is what the ATF was phrasing it as. And the ATF basically said that's not a get around for what we already decided. They initially said that because it shot 410 and 45 long Colt, that's what made it not an NFA item. Franklin Armory tried to get around that with their 556, and ATF said, nope, that's not a workaround for us.
Yeah, and ultimately what they said is, like, if we just allowed any exotic, rare, maybe not even in common use cartridge, and this was the idea that I was having, so I guess we're all on the same page, but that would defeat the entire Gun Control Act. It would defeat all these regulations. Guess what? The government doesn't like getting defeated, so they clawed that back, and they're pretty harsh on Franklin Armory.
They really are. Yeah, this is a pretty harsh letter from ATF, but it does clarify it. ATF said that they wanted to make it very clear about their classifications of firearms. Sounds as though they're not trying to reclassify any firearms, so that's good news for us. It sounds like Franklin Armory and ATF had a little bit of a miscommunication.
Well, the ATF calls it falsely represented.
Well, yeah, okay. Even more than a miscommunication about what was being approved.
Yeah, and so, we'll continue to monitor the situation. We'll let you know. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to leave your questions in the comment section down below. Until next time, we're the Armed Attorneys.